A common misconception that people often have is that the police are always required to read you your Miranda rights anytime they stop you. This isn't entirely correct. The police are only required to read you your Miranda warnings if you're the subject of what's known as a custodial interrogation. What is and is not a custodial interrogation is a question of law, and the courts have held that certain types of questions, such as what's your name, where are you going, do you know why I stopped you, have you been drinking, and do you have any drugs or weapons on you, are not considered to be custodial interrogations. What you do need to remember when dealing with the police is that you always have the right to remain silent. Under Indiana law, you are required to identify yourself when asked by a police officer, but nothing further. If the police ask for permission to search you, your home, or any vehicle that you happen to be in, you should always refuse. They may still have a legal basis for searching anyway, but you should never voluntarily give up any of your constitutional rights. If the police continue to try and question you, your only response should be to tell them that you will answer no questions without your attorney present. I see many cases where the only real evidence the prosecution has against my clients are statements made to the police in response to questioning. When dealing with the police, you should always remember that they have one goal in mind: putting you in jail. The more you talk to the police, the easier you make their job, and the harder you make my job. Even if you have made a statement to the police, that doesn't necessarily mean that statement can be used against you. There are very specific evidentiary rules that cover when a statement can and can't be used as evidence in trial. If the statement was the product of threats or force or coercion, that statement may not be admissible. If you or somebody that you care about has recently been arrested, contact me immediately at 317-989-1129, and we can begin discussing the necessary steps needed for the defense.